Okay, thank you very much for introducing the introducer, actually. So I'm very happy and proud that I have this honorable task to introduce Jennifer Davis to you from Catholic University, Washington. And it's very honorable for two reasons, actually. First of all, because of the long-standing connection between my university and the American Academy here in Berlin, and both situated in what once was the American sector of West Berlin. And secondly, of course, because I'm quite familiar with Jennifer's work. For several years, we share a lot of work, a lot of interests we have in common, and so, well, I'm very happy that I can do this. Jennifer Davis did her PhD at Harvard with Michael McCormick, who's one of the most prominent historians of the early Middle Ages. And her work focuses very much on early medieval law. Now, Michael McCormick is actually not an expert on early medieval law, so this tells us something about his generosity as a supervisor, but it also tells us, I think, a lot about, about Jennifer Davis pursuing her interests and convincing her supervisor of supervising a thesis on a topic which is not so familiar to her, and also about her interest and capability to develop her research into a very personal, original direction. Now, her masterful book entitled Charlemagne's Practice of Empire, which was published last year by Cambridge University Press, is a highly original reappraisal of the reign of Charlemagne, founder of the Frankish Empire that once comprised half of Europe. Charlemagne has, of course, been dealt with many generations of historians coming from France, Germany, Belgium, later also from Britain, and the same also holds true of the topic of law and governance under Charlemagne. But European research has often been dominated by an approach to see Frankish history more or less anachronistically, as part of constitutional history, very strong influence coming from the 19th century. And as there are many historians today who now try or tend to interpret Frankish history in a very different, or we could say into the opposite direction, actually denying the Carolingian Empire the quality of statehood and saying there were no true institutions and no concept of what the state actually was. These are typical German, or should I say European traditions of scholarships and debates. I'm not sure whether it is helpful to characterize what you are going to do or what you are doing or your approach as American, whatever that may mean. But I think one of the reasons why her book was very cheerfully acclaimed also by German scholars such as Karl Ubel recently is that her approach is actually on the Carolingian Empire under Charlemagne, on Charlemagne as a very dynamic figure, as a ruler, the top of some sort of constitution, but as a ruler in a situation which is maybe characterized by a very dynamic process of expanding an empire, and also by his functionaries trying out new things and trying to cope with the problems arising from the periphery and try to making ideas of how you could conceive this as an empire, as a general, a realm that extends from France to Italy and so on. So these are few of the topics of her book, which also focus on the question of unity and diversity, on within such a big empire, on the question of centralization or the relevance of local traditions. And so I think in between these antitheses, her book is perhaps the most interesting discussion we have in recent times on this field, this particular field of history, which is actually well known to historians, but has not been seen, not been interpreted in such a way. And it is also interesting that, well, on Charlemagne, a lot of books, articles have been published, but only very few monographs in recent times, whereas it seems to be a certain German preoccupation that people, German medievalists, tend to write biographies of Charlemagne. In particular, professors who have retired like to do this. But this is one of the few monographs, actually, that really deals with a special topic of the governance praxis. And I think this makes a contribution, one which will be very much, or is already very much discussed within the field among these early medievalists. Now, the research she's carrying out while being here at the American Academy, and which she will be continuing next year while being a member of the Institute for Advanced Study in Princeton, she will focus on Frankish legislation in a broader perspective, ranging from the Merovingian period actually to the 9th or even 10th century. The so-called capitularies, capitularii, these are decrees, collections of chapters on a wide range of legal, administrative, or even pastoral topics. They were sent out through the empire from the center into the regions of the periphery. These capitularies are a notoriously difficult subject or difficult corpus of texts for several reasons, because it's very difficult to define what is actually a capitulary. Is it a law? Is it a modern piece of legislation? Or is it some sort of ad hoc mandate issued for a very particular purpose? And all these things. The other major problem with capitularies is that there is no modern edition which is sufficient to work with them. So we cannot simply take the texts as they had been printed in the 19th century, but historians have to look into the manuscripts, actually, which is at the heart of the research doing on these particular texts. And this is why, among other things, she is here, because there are many manuscripts in Berlin, of course, also in Paris and Rome and elsewhere. But she also does a lot of manuscript studies on these legal texts, and we have a particularly rich manuscript collection here at Berlin's State Library. So I think she will also lead us into this domain tonight. And I think we are all very curious, and where she lead us from the center to the periphery to see from the manuscripts how the Charlemagne's empire, or the Frankish Empire, was conceived from the periphery, and how local officials coped with the problem of, representing the authority of the ruler, but at the same time being torn in between the traditions and also the expectations of the local population. And so very curious, and we are all looking very much forward to this. And thank you very much for making this possible, for inviting us to participate in this in this event, in this magnificent building. And we are very much looking forward to listening to your lecture, and the floor is yours.
So I need to begin tonight with some thanks, and I wrote this down because I have a lot of people to thank. First, I do need to thank Stefan for his very kind introduction. So as Stefan has just told you, one of the major problems with capitularies is the lack of a satisfactory edition. And as someone who works on this material, I'm delighted that a new edition is coming and that I don't have to do it. But Stefan does. So Stefan is part of a group that is re-editing the Frankish Capitularies, this type of law that I will be talking about tonight. And Stefan and his fellows have been tremendously generous to me over the years, sharing ideas, inviting me to conferences, sending off prints, and so on. And I've learned a tremendous amount from their research. And in addition to his work on the Capitulary edition, Stefan's scholarship has made a significant contribution to how historians today, me definitely included, understand early medieval law, in particular through his work on the oath and on how early medieval legal culture emerged out of Roman precedents. So I'm particularly grateful that he was willing to introduce me, for his welcome to Berlin, and for his generous collegiality. So thank you, Stefan. My second set of thanks needs to go to the American Academy, where I am tremendously honored to be the John P. Birkeland Fellow this fall. The Academy staff goes above and beyond to make the fellows comfortable and to provide an ideal environment in which to work. And I owe a particular debt to John Thomas Eltringham, thank you, for his help in arranging tonight's lecture, and also to the Academy's librarian, Yolanda Korb, whose patience and ingenuity in finding incredibly obscure works of scholarship I regularly test. I alone could be her job, basically. I am also very grateful for the company of my fellow fellows, whose congeniality, insight, and generosity has helped make this semester a particularly pleasant and fruitful one. It is a great privilege to be at the Academy, and I very much appreciate the opportunity. My final word of thanks needs to go to Dr. F. Overhow, who's here, yes, who is also here tonight. He is the director of the Handschriftenabteilung at the Staatsbibliothek here in Berlin. And as Stefan suggested to you, my primary reason for coming to Berlin was to study the manuscripts of capitularies preserved in the Staatsbibliothek. F has extended me a very warm welcome, offered very useful information and suggestions about the manuscripts I'm working with, and has generally made working at the Staatsbibliothek very easy. And I highlight this because it is actually not always true that manuscript libraries or librarians are particularly welcoming to scholars. Yes. So it is increasingly the case that manuscript libraries are run by administrators who don't have a background in scholarship. And having a scholar, as you do in Berlin, in charge makes a tremendous difference in how materials are treated and preserved and in how accessible the collection is to other researchers. So I'm tremendously grateful to Dr. Overhow for facilitating and aiding my own research. But I have to say that I also think it speaks very well of Berlin that the Handschriftenabteilung remains a true center of scholarship, as manuscript libraries used to be. And for the Berliners in the audience, if you don't know about the Handschriftenabteilung, this is an institution that you should be proud of, and one that stands out. So, manuscripts, like those preserved in Berlin, which houses thousands of medieval codices, are at the center of my current research, and they're what I would like to talk to you about tonight. So I'm going to begin with a little bit of orientation on what exactly capitularies are. As Stefan has told you, figuring that out is actually not so simple, and say something about why historians are interested in them. I will then present a brief overview of the corpus of manuscripts that contain capitularies, and then I'm going to offer a case study of a particular manuscript in order to explore some of the ways in which medieval people made use of capitularies. Finally, I will conclude with a few observations about how foregrounding manuscript evidence contributes to our understanding of the capitularies and the history of the early Middle Ages more broadly. So first, for some background. And I know a lot of this is going to be familiar to the medievalists here, but bear with me. I'd like to try to give some context for those who are new to capitularies. So the capitularies are a form of early medieval law. The name is derived from the Latin word capitula, which means chapters, as these laws are typically, although not inevitably, divided into chapters. I still think that the best definition of capitularies we have remains that of François-Louis Gansoff, who characterized capitularies as, and I quote, acts of power, subdivided into chapters and produced by Frankish rulers to express legislative and administrative decisions. Now, this may seem a rather loose definition, and it is. Figuring out which early medieval texts we should classify as capitularies remains a deeply contested issue. Indeed, just about everything about capitularies is debated, including if we should count some early texts produced by the Merovingian dynasty as capitularies. I am at this point in my research doing so, albeit with some hesitation. how linked to kings capitularies really were. I think they were very strongly linked to kings, and I'll make that a part of that argument today. And how effective they were, which is a very large topic, but one that I'll touch on at least in some ways. Now, despite the fact that historians don't agree on just about anything about capitularies, we all basically do agree that they are important. They were produced and copied in great number during the Middle Ages, and they touch upon just about every topic of interest conceivable. Now, this may be law linked to kings, but it addresses topics that we would consider far beyond the scope of secular law. Capitularies range from gathering the army, to perjury, to ordaining priests, to cloistering nuns, to fruit trees on royal estates. Moreover, while the early Middle Ages was a period of great legal creativity, the capitularies are a particularly Frankish form of law. There are just a few possible exceptions to this, but in all cases they can be linked to Frankish influence. They thus stand out as an exceptional component of the legal landscape in the post-Roman world. For all these reasons, it behooves us, as historians, to understand how these texts worked. Produced from the 6th century, at least if we're counting the Merovingian material, to the 9th, capitularies continued to be copied regularly through the 12th century when the transmission did decline, before resuming in a new form in the early modern period. While they are particularly associated with the Carolingian kings, the Carolingian dynasty lasted in the broadest terms from 751 to 987, although the Carolingians did produce capitularies before they usurped the royal office. So particularly associated with the Carolingian kings, nonetheless, the capitularies are a major source for the history of the Middle Ages in general, in political, cultural, social, and religious terms. One of the most remarkable features of the capitularies is that despite their importance, the kings who produced them made minimal arrangements to ensure their transmission. That is, most capitularies were copied locally by individual scribes and patrons who chose to copy capitularies for their own reasons. My new book project seeks to reconsider the genre of the capitularies, which have not been the subject of a monograph in about 60 years. By rethinking what capitularies were and how they worked, I hope to shed some new light on the social and cultural transformations of the early Middle Ages. The manuscripts that show us how individuals and communities within the Frankish orbit took up capitularies and put them to use for their own purposes are a key part of this story. I am thus interested primarily in the manuscripts as examples of the use of law, which is why it is so important for me to see the manuscripts in the original. I get asked a lot why I need to travel to see manuscripts when so many are now digitized. And it is great to have digital copies, which absolutely do facilitate research, and they're going to allow me to show you some nice pictures tonight. But manuscripts are not only transmitters of texts. They are objects that show signs of use and wear not evident in even the best images, and they must be investigated as objects. That is, as cultural productions that require unpacking and analysis. With this in mind, let us now turn to the surviving corpus of manuscripts. Now, depending on how one would like to count, there are somewhere between 250 to 300 capitulary manuscripts extant. I've seen about 200 of them thus far, so I'm on my way, but we have ways to go. Like all handmade products, each capitulary manuscript is different. In attempting to characterize the use of law as reflected in the manuscripts, one needs to attend both to the manuscripts in the aggregate and to the particular details of individual codices. While I cannot offer a full overview here, I'd like to start with a few examples to illustrate the range of surviving manuscripts before I move on to the case study. Now, there are some early manuscripts of capitularies, however, most date from the late 8th to the 12th centuries. I'd like to try to indicate two major features of the corpus of manuscripts in the aggregate, namely their diversity and how they change over time. The vast majority of capitulary manuscripts are manuscripts that contain capitularies along with other texts. So that is, it's not just capitularies. There are exceptions to this, but most manuscripts then are combining capitularies with some other kinds of materials. The nature of these other materials, as well as other hints in how capitularies were copied and laid out on the page, allow us to analyze the range of contexts in which capitularies were perceived to be useful. Perhaps the most common context in which capitularies were preserved was in legal and administrative books. One common form of this is national laws combined with capitularies. And this is a 10th century Frankish manuscript from here in Berlin. These can also be more focused administrative books, such as books for the missi, who were royal overseers who sort of check up on everything that went on, which is what I think likely is the case with this Vatican manuscript that you see here. Capitularies were also transmitted in the context of other kinds of law, such as the Canon Law Manuscript, that is right here. This is the Vetus Gallica, one of the important early medieval canon law collections, with Capitulary of Charlemagne as well. They're also preserved in contexts that are not legal, such as theological manuscripts, such as this one, which includes the earliest full copy of the Admonitio Generalis, Charlemagne's Great Reform Capitulary of 789, or manuscripts, for example, concerned with the nature of monastic life. And this one here is particularly famous for the copy of the Rule of St. Benedict that it includes. Some are simply sui generis, as this very famous Paris manuscript is. Despite much attention, its nature remains unclear, partly because nothing else like it survives. And if it looks really weird and you're confused, the top half is in Turonian notes. The majority of the transmission is in the form of codices or manuscript books, but we do have some surviving fragments. This is one that was later rebound into another manuscript. Most of the fragments were almost certainly originally from codices. But we also do have a few precious rotuli, or rolls, which may have been one of the forms in which capitularies were originally promulgated, whatever that might mean, which is problematic. And this is actually not a capitulary. It's a more administrative document, but it was one of the best examples I could find to show you today. So over time, the nature of capitulary collecting changed in important ways, including a growing tendency to include many capitularies in one manuscript. This is an example from the Bibliothque at Yale. The eventual creation of very large compendia manuscripts that take a historical approach to the capitulary texts they contain. This Paris one is one of the most important manuscripts for the determining of the entire capitulary tradition, and also to the claiming of the capitulary tradition by non-Frankish peoples, and this is one of the most famous of the manuscripts. And this is Charlemagne and his son Pippin dictating law to the little scribe who's ready to write. Post-Carolingian manuscript. While there is much more to be said about the manuscripts as a corpus, in order to give us a sense of more detail, and I know I've gone through these really fast, so now we're going to spend the rest of the time on one manuscript. So what I'm going to do now is to introduce one of the most famous law books from the early Middle Ages, St. Gallen Stiftsbibliothek 731. There's its title page. This manuscript includes 3 so-called national laws, that is, laws produced for the Germanic peoples and also their subjects, but the Germanic peoples who entered Roman territory under the late Empire and later ruled the successor kingdoms that followed the end of the Roman Empire in the West. Our manuscript includes an abbreviated copy of the Lex Romana Visigothorum, which means the Roman law of the Visigoths, which is not actually what this really law is, but nonetheless, that's what we call it. The Salic Law, with a copy of the Decree of Childebert, which is a Merovingian capitulary, often transmitted with the Salic Law, and a text that Stefan has worked on. And this is the part of the capitulary in the manuscript. The Salic Law also comes with a king list, a list of kings, Frankish kings, and a copy of the Lex Alamanorum, or the Law of the Alamanians. The manuscript also has a genealogy of Jesus in between the legal texts. And I know this is a lot of strange names, but bear with me. I'll come back to unpacking somewhat what these things are. So this manuscript is famous for a number of reasons, but 2 in particular are relevant for us today. So first, unlike many early medieval law books, it's illustrated. So most of these illustrations are in the form of decorated initials, like the ones you see here, or another example. But it also includes a famous full-page illustration, which is here, which has most often been interpreted as a depiction of a lawgiver. Klaus-Dieter Schott, building on work of Hubert Mordek and Jacques Foviot, as well as some others, has argued that what this image presents is sort of a conflation of images of lawgivers from David and Moses, well, Moses and David, to the present, so that in some sense it's actually representing or evoking Charlemagne. I'm not convinced by this interpretation, which I think is reading too much into an image with really difficult iconography. It's also been suggested that this is depicting one of the missi, those overseers that I mentioned, which is an intriguing suggestion, but I don't really see how you would prove that. So I think it's a problematic image, so I'm going to leave it at that, but we can talk about it more if anyone would like. Now, the manuscript is most famous, however, for its scribal colophons, which are notes from the scribe who wrote the manuscript. So in the colophons, the scribe identifies himself as Vondel-Garius, so this is often called the Vondel-Garius Codex. And in the final colophon, at the end of the manuscript, he dates his completion of the book to November 1st, 793. So this is the final colophon. So we have Vondel-Garius' name here, and this part here is giving some dating information, as well as asking for a prayer. Now, these kinds of dating clauses are very rare, but they make medievalists very happy. And this is because most manuscripts are dated by content and by script. So what this actually means is that we can get a first indication of the date of the manuscript if we can date the text that it contains, which is not always possible, but when it is, can provide a basic terminus postquem. More precise dating arguments are derived from a paleographical analysis, or study of the script of the manuscript. So script changes over time, but there are patterns in how books are written that vary by time and place. So evaluating the script, including the different kinds of display scripts, and by this I just mean very simply the kinds of how you indicate a break in a text. So for example, something like this and then this. Display script, punctuation, other kinds of features of this kind allows paleographers to offer dates for surviving books. Now, the problem is that such a process of dating is an art, not a science, and it's usually not especially precise. So, for instance, if we can localize a book to within 2 decades, that's a narrow range. So, in this case, the colophon allows us to ascribe the book to a particular year. So, historians who are really worried about chronology and things happening in order, this is a good thing. Now, it also, of course, raises the question of who exactly this Vondel-Garius guy was who wrote the book, and he did write the entire book, including the illustrations, which is not necessarily common. So unfortunately, unlike the dating clause, we cannot be so precise about Vondel-Garius. The style of the script, as I've suggested, does give us some guidance to where he wrote, which was likely Burgundy in its medieval sense, potentially sort of Western Switzerland, so this gives a sense of where we're talking about here. We do know of a particular cleric named Vondel-Garius from Lyon, so here, who had ties to the region of Alemannia where the manuscript ended up, eventually. Now, the connection has led some scholars to propose him as the scribe of this codex, but the name alone does not allow us to tie the cleric from Lyon to St. Gall 731. It has most recently once again been suggested that he was a lay notary, an idea that I find compelling. That he was a notary is basically certain from the subscripsi sign at the end of the scribal colophon, which is typical notarial practice. So this is from the bottom of the colophon page, and this here is a mark that a notary makes to indicate his work. Now, there has been some research suggesting that Vondel-Garius could have written on royal commission. This is in the older literature, not the more recent literature. I don't see any evidence of it, and I'm therefore going to, from now on, leave that aside and treat it as very much a local manuscript, and quite explicitly not a royal one. So, while we may never know more about Vondel-Garius the scribe, his use of a dating colophon has significant historical implications. A recent important study of this manuscript by Ildar Garbzanov has drawn attention to 2 of the illustrations in this manuscript, illustrations that have long been known, but whose import deserves further analysis. These 2 illustrations depict Charlemagne's monogram. So the monogram was used on diplomas, which is basically a kind of legal document recording gifts and other privileges from the king. And monogram, and this is one of Charlemagne's charters, in this case a gift from 775 to the monastery of Hersfeld. So they're one of the signs of authentication that mark out a document as genuine. So this is the monogram right here. And this is just the detail, which is, sorry, a little fuzzy, but at least gives you some sense of what this looks like. And this is the monogram then in the manuscript, right here. This is its position on the page and then in detail. So this monogram, the Corollas Monogram, so basically what we're doing, the name Corollas for Charlemagne, K-R-L-S. Okay, so it's just a representation of the name. It's the most common representation of Charlemagne's power during his own reign. The monogram was also used on one of Charlemagne's coin types, the so-called monogram or reform coinage. And this is an example from here in Berlin. You see again in the center we have the Corollas monogram. And indeed, one of the other illustrations in St. Gall 731 shows the monogram coinage. So this is our other picture here, and then with the detail. So a picture of the coin. It is not a totally precise rendering. There are a couple of ways in which the coin is off. So we can talk about that too, but it's close, recognizably a coin. Now, Garabzonov and Simon Coupland have both recognized that the depiction of the coin in this manuscript actually helps us date the reform that introduced this new form of coinage, which was to have a very long future in medieval Europe. And we put them together. Now, the purpose of Garabzonov's study was to redate this coinage reform and to offer a context for it in the events of the reign of Charlemagne, who was the most famous of the Frankish kings and who ruled from 768 to 814. Now, in the course of so doing, Garabzonov made 2 points that I'd like to build on here. So first of all, he noted that the coin and the monogram are both signs of royal authority, and more specifically of Charlemagne's authority. Second, he noted that the images are not placed randomly, but next to particular chapters. So the monogram image introduces the title of the Lex Romana Visigothorum about judges, and the picture of the coin is appropriately enough used next to a chapter on coinage, or starting a chapter on coinage. Now, Garabzonov suggests that these chapters were so marked out because the laws in question were still in force during Charlemagne's reign. What I'd like to do now is suggest a different interpretation of these images and what they tell us about legal culture in the Carolingian period. While there is much else to be said about this codex, I'm going to focus here on these evocations of Charlemagne in the manuscript and their implications for the understanding of law in the late 8th century. In so doing, I seek to build on some important work by Klaus-Dieter Schott, who also recognized the emphasis on Charlemagne in this manuscript. Schott argued that the manuscript was not so much meant to be used, but rather it was intended to express an ideological vision of Charlemagne as the culmination of a Roman, Christian, Frankish legal tradition that corresponded to the empire to be revived with Charlemagne's imperial coronation in the year 800. I can't really see any such tie to the ideas of a Christian Roman Empire in this manuscript, per se, and I'm going to instead attempt to demonstrate that the manuscript reflects the legal culture just beginning to emerge in Charlemagne's capitularies. So in order to do this, I'm going to say a little bit about the national laws, but bear with me because capitularies are indeed the point. Now, to my mind, one of the most significant features of St. Gall 731 is that it firmly asserts a link between kings and law, especially between Charlemagne and law, and it does so in ways that evoke particular royal concerns. The images depicting symbols of Charlemagne's authority are not the only signs of royal power in this manuscript. The emphasis on royal power is also repeated in some of the dating clauses and in the colophons. So the copy of the Salic Law, for instance, is dated by reference to Charlemagne's regnal years. So this is where we have the date here, and then in the detail with the reference here, Corollo Rege. The regnal years are also used in the colophon that ends the manuscript, placed just after the end of the final text in the manuscript, the Lex Alamanorum. So we've seen this page before with Juan Dogarius, but here's the reference to King Charles. Now, the use of regnal years to date texts is entirely common in the Middle Ages, so common indeed as to be banal. However, the ways in which symbols of Charlemagne's authority are inserted into this manuscript bear emphasizing. This is primarily because the texts contained in this manuscript were not produced by Charlemagne. The manuscript thus does not include his law, yet he is linked to the laws presented. Thinking a bit about what these legal texts are and the ways in which signs of Charlemagne's authority are inserted can clarify the understanding of law reflected in this manuscript. So let me say a few things about these legal texts. All of the legal texts in this manuscript present more or less serious problems of interpretation, but I'm going to try to offer just a basic introduction so that we can think about how the indications of royal authority inserted into these texts work. So, medievalists, I'm going to skirt over some of the worst parts of technical legal history, but hopefully this will give us a base on which to discuss. So, the first text in the manuscript is this Lex Romana Visigothorum, a text also known as the Breviary of Alaric. It was promulgated by the Visigothic king Alaric II in 506. The Lex Romana Visigothorum is a compendium of Roman law, including selections from the Theodosian Code, which was the first imperial codification of Roman law, later novels, which were legal statements of Roman emperors, and writings of Roman jurists. It was the most popular codification of Roman law in the early medieval period, surviving in more than 100 manuscripts. Now, despite the name, which is a scholarly invention, and the fact that it is connected to the Visigothic kingdom, we do have to see this text as a more general codification of Roman law, Roman imperial law, not as a purely Visigothic or Spanish text. And it's in this text, as I suggested earlier, that the images showing Charlemagne's coinage and monogram are inserted. The second text in the manuscript is a copy of the Salic Law, which is one of the two traditional laws of the Franks. The Salic Law is traditionally thought to have been originally compiled sometime in the early 6th century, but it was repeatedly reworked. Charlemagne's court produced two versions of the Salic Law, one now convincingly, I think, redated by Karl Ubel to 789, so just a few years before our manuscript was written, and the second in the early 9th century. However, the version preserved in St. Gall 731 is an older version of the Salic Law, the so-called D version, thought to have been revised under Charlemagne's father Pippin in 764. So it is this text that's dated by Charlemagne's regnal years. So if we go back to that image here, the dating clause is found just after the prologue and before the list of titles contained in the law. So we have end of the prologue, and then we have the incipit here, dating clause, and the list of the titles. This is a very standard placement. But the clause then is actually giving us the date when the law was copied, not when it was produced, which inserts reference into a copy of the law as it was revised under his father, despite the fact that Charlemagne himself had already produced a new version of this same law. Now, as Charlemagne's revision of the law had taken place just a few years before the manuscript was written, it is entirely possible that Vondel-Garius did not know of the new version. And this is also very far from being the only example we have of copying of supposed out-of-date law in the Carolingian world. It is nonetheless noticeable that Charlemagne's regnal years are inserted into a text that he did not produce. And it's particularly worth noting because the link between Pippin and this version of the Salic Law is also reinforced later in the manuscript. Following the Salic Law and the Merovingian Capitulary is a list of Frankish kings with some additional notes taken from Isidore of Seville's historical writing. Including such a king list in a manuscript of the Salic Law is again very common practice. The list, as given here, and you see it here, ends with Charlemagne's father Pippin. So it's Pippin here, and then this is counting various years between different rulers. So he's the last actual king listed. Now, this is actually not unexpected as a way of giving the king list, but it's still underlining the links between this law and the earlier Frankish kings, despite the dating that then relates to Charlemagne. As with the Lex Romana Visigothorum and its images, the Salic Law here is tied to the ruling king despite his lack of involvement in compiling that text. The final text in the manuscript, the Lex Alemanorum, is less tightly linked to Charlemagne. The final dating reference to Charlemagne is found after the Alemannian Law on this final folio of the manuscript. Oh, sorry, this is the close-up with Pippin, so you can see. This is our final dating. There we go. Our final dating clause. So it's on the final folio after the Alemannian Law. It does seem to me, however, that this final statement, which is found right after that law ends, does allow us to suggest that for Vondel-Garius, this text too is part of this one book. This book is what he calls it in the colophon, which he's dating the entire book to the reign of Charlemagne. So the connection here is admittedly less direct, but I would contend that the Alemannian Law is still presented as being under the penumbra of Charlemagne's authority. Here too, though, the law is not something that Charlemagne produced. Once again, the nature and composition of the Lex Aluminorum is debated. The standard view has been that there are two recensions of the Alemannian law in addition to an earlier Pactus. The St. Gall copy of the Alemannian law is significant in that it is only one of two manuscripts that ascribe the composition of the text to the Alemannian Duke Lanfrid. So this is the prologue that we see here, and then in detail with the reference here to Lanfrid. Now, this is notable because most versions of the Alemannian law note the influence of the Merovingian kings. This version, however, characterizes the law as a more independent Alemannian production, not a Frankish one. Now, the Alemannians had long been dominated by the Franks, but the final vestiges of Alemannian independence were destroyed by Charlemagne's uncle just under 40 years before the manuscript was written. So here, too, we have an older law with its own history that is still presented as having something to do with Charlemagne's power, despite the fact that the manuscript in other ways reflects the non-Frankish character of the text. In a sense, then, we can see this manuscript as underlining or evoking Charlemagne's authority in all of its three main parts, and despite the fact that the texts it contains were not promulgated by Charlemagne. The repeated evocation of Charlemagne in a manuscript not containing his law, written far from his court, and with, as far as I can see, no discernible link to the court, is worthy of stress. The materials in this manuscript are not Carolingian royal law in a simple sense, but the references to Charlemagne suggest a deeper, if more diffuse, connection. All law, in some ways, or at least all good law, is tied to Charlemagne. The relationship between early medieval kings and law, particularly the national laws, is complex. Some recent scholarship has sought to downplay the royal nature of law, particularly the national laws, but also the capitularies. I would say that this manuscript is evidence against that interpretation. The references to Charlemagne here present him as linked to the legal text contained in the manuscripts without directly ascribing to him responsibility for the individual texts. Rather, Charlemagne's power is intertwined with law so that royal authority and legal authority become mutually reinforcing. I must stress that this is not a royal vision, but an entirely local one that nonetheless underscores the connections between the ruling king and law. To me, this indicates a world in which law is importantly, albeit not exclusively, royal. I would like next to look a bit more closely at the depiction of the monogram and of the coin included in the copy of the Lex Romana Visigothorum. So these two images here. Now, as I noted earlier, Garzanov has recognized that the two images are not placed randomly in the manuscript, but rather correspond to the titles of the Lex Romana Visigothorum that they begin. The monogram again beginning a title on justice and the coin a title on coinage. So Garzanov has explained this by saying that the particular regulations were still in force when Vondel-Garius wrote, at least in some areas. Now, he's certainly correct that these images have much to tell us about the construction of royal authority. However, rather than seeing them as marking out passages still in force, at least for people subject to Roman law, I think we can better understand them as indications of the transmission of royal concerns to the far-flung regions of the Carolingian Empire. So we can make this argument both by looking at the nature of Frankish legal culture and at the specific titles marked out with symbols of Charlemagne's authority. Let's begin with Carolingian law. Now, the national law codes certainly remained in effect in some ways in the Carolingian period. So that might sound for non-medievalists like a very simple statement. It's a pretty contested thing to say. There has been a major school of thought that sees the leges, in particular, the national laws, as purely ideological works, that they have no practical purpose. They are simply statements of sort of rulers as lawgivers, that they're made purely to sort of show that you are a ruler. Okay? I think we need to leave room for use of some kind. So that's where I'm standing in this material. And why do I say this? Well, some of these texts were revised by the Carolingians, and Charlemagne ordered written codes to be compiled for peoples he ruled whose customs had never before been codified in writing. The national laws continued to be copied in great number. Now, how exactly the codes were used is a much more difficult problem. Scholars used to argue that legal practice was shaped by the principle of personality of law. That is, that a person would be judged by his own law regardless of where he happened to be physically. Thus, Franks in Italy, to give one example, were still judged according to Frankish law. Now, how much this actually worked is a more vexed question, along with multiple other points about the use of the national laws. Now, scholars now recognize that this idea of personality of law cannot fully explain our evidence. It assumes an ethnic character of these laws that they do not have in any kind of simple way. Okay, so this is clearly not the only explanation for what's going on. What we're going to replace personality of law with is less clear in the scholarship. Okay, so where we've gotten in the scholarship is that we all recognize that the old answers don't work. We have no consensus on what the new answers should be. Okay. Now, I'm certainly not going to fix these problems, so let me just pull out a couple of bits that are important for what I want to say about St. Gall 731. Namely, what Garibsanov is doing in claiming that these laws are still in force is that he's basically assuming that those two passages with the drawings linked to Charlemagne were valid in areas subject to Roman law, which he is assuming that a place like Burgundy, with a presumably originally Roman population, would have been. Other interpretation, like Schott, has seen this Roman law, including the Lex Romana Visigothorum, as a text more generally relevant for a realm on the verge of becoming an empire, albeit that's an argument that he's making largely in these ideological terms. I think that's overstating significantly the applicability of Roman law in the late 8th century, but regardless of how we sort of resolve this ideological use and how we think about the geographical scope of the Lex Romana Visigothorum, either way, there's still a problem in linking the images to passages meant to be carried out by royal agents. And the difficulty here is that the national law passages on coinage and justice, this idea that they were being directly enforced by Charlemagne. So Charlemagne may not have ever challenged the overall validity of national laws, and in certain ways, indeed, I would say that he sought to reorganize and extend the reach of these materials. His own legislation was valid for the entire empire. This, too, is something that has been challenged recently, including in a recent book by Thomas Faulkner, which I am at least implicitly arguing against here. And medievalists, we can talk about why, if you'd like. So Charlemagne had actually a great deal to say about justice and coinage, as I'll say a little bit more about in a moment. But when he did so in the form of capitularies. Charlemagne's rulings on justice and coinage were meant for his empire as a whole, and not just for any parts of it linked to particular national laws. When it came to justice and coinage, he was not carrying out multiple rulings taken from many different forms of law valid in the empire, but making his own rulings in the form of capitularies. So, for instance, the earliest surviving written source to address Charlemagne's control of the coinage is a capitulary for Italy, meant to impose Frankish coinage on Charlemagne's newly conquered Italian kingdom. So even coinage legislation directed at a particular region was meant to bring it into line with practice in the rest of the realm. When it came to justice and coinage, Charlemagne legislated for the realm as a whole, and again in capitularies. So I would thus argue that the images of Charlemagne next to these passages in St. Gall 731 are not showing any kind of direct enforcement of those particular decrees, but a recognition that these are topics linked to Charlemagne and linked to his legal work. I would argue that this interpretation is supported by the actual content of the passages in question. So the first of the two images is a picture of the new denarius, the silver coin introduced in 793. And I'm using here Simon Kuplin's dating rather than Ildar Garibsanov's dating. So the title of the Lex Romana Visigothorum that the initial begins offers a reward to those who reveal forged money and threatens those who produced it with burning. The subsequent chapter, as given in this manuscript, which is a very particular copy of the Lex Romana Visigothorum, so it sits next to the male figure who is holding up the image of the coin. So this little guy here is standing next to another chapter. That chapter threatens those who replace a valid coin with forged or who produce such coinage with capital punishment. Longer versions of this chapter exist in other copies of the Lex Romana Visigothorum, and they also prohibit other forms of coinage manipulation, such as clipping the edges. Now, the reform of the coinage was one of the most notable achievements of Charlemagne's reign in terms of the quality of the coins, their regularity, the volume of circulation, and the Carolingian ability to exclude foreign coinage from their territory. Not all of the changes and decisions related to the coinage are reflected in written sources, but the texts of the period do talk about coins. And again, the vehicle for Charlemagne's regulation of coinage, as I've noted, was the capitularies. And while the capitularies do express concerns about forged coins, none of them clearly suggest capital punishment for forgers. Now, this is not especially surprising, as capital punishment was much more common in late Roman as opposed to early medieval law. It's somewhat more difficult to discern what the punishment inflicted would have been. The references to forged coinage in Charlemagne's capitularies do not prescribe a penalty. Later capitularies usually assign amputation of the hand as the penalty for forged coin, although there is one narrative source from a little later in the 9th century that records a man blinded for this crime. Now, as the legislation postdates the manuscript, it is conceivable that coin forgers were killed earlier and then that this procedure was changed, but that seems to me highly unlikely. So the use of capital punishment in this situation doesn't really find any resonance with other Frankish evidence, and the resort to burning would be surprising in Francia. The penalties for most failings related to coinage prescribed by the capitularies are fines or loss of office, which is pretty standard for how Carolingian capitularies deal with failings of various kinds. Moreover, judging from the surviving finds of coins, forgery seems to have not been especially common, information that I owe to Simon Coupland. In short, the approach to coin forgery taken in the Lex Romana Visigathorum is out of step with Carolingian sources. Thus, while it is absolutely true that anxiety over coinage and its forgery remained a major concern of Charlemagne's, the particular passage in the Lex Romana Visigathorum opened with a picture of a coin cannot be said to be enforced during the reign of Charlemagne. The second passage, marked with the symbol of Charlemagne's power, diverges less from current Carolingian practice, but is still not a perfect match. And this is our monogram here. The passage, as given in the St. Gall manuscript, states that judges must return anything that they have seized wrongly, or that the loss will be made good by their heirs. Now, this is a fairly obvious requirement of judicial probity, and thus Carolingian judges would certainly also be required not to take property without cause. So the spirit of the passage in the Lex Romana Visigathorum corresponds to Carolingian practice, but there's nothing in Charlemagne's capitularies that I'm aware of that matches the passage exactly. In the case of the coinage, we have limited Carolingian legislation to work with, but what we do have does not match the Lex Romana Visigathorum. In the case of the judges, the basic idea would have been reasonable to the Carolingians, but despite the copious legislation on justice, no precise comparandum is available. And justice is Charlemagne's favorite topic in the capitularies, so there's a lot in this case to work with. Now, it has been suggested by Rosamund McKitterick that this book was written for a count. Counts were local officials, the primary local official in the Carolingian world, and thus in many cases the judges of first resort. And that's entirely possible. However, I cannot see that the passages marked by obvious signs of Charlemagne's authority were so marked because they were highlighting particular regulations a judge was meant to enforce in any kind of precise terms. Rather, what these images do is highlight topics of great interest to Charlemagne. Now, 793 was still early in the process of Charlemagne issuing capitularies, but the texts that we do have for the first half of the reign, as well as the actual coins themselves, already display the attention to coinage and the constant emphasis on justice that would mark out the capitularies of the later years. These concerns were most clearly articulated in capitularies, although they also would have been announced in assemblies, both royal and local. What I would argue we see in these images is a scribe far removed from the center of Carolingian power, who had nonetheless realized that control of coinage and attention to the character of justice were major concerns of the king and his court. The images link Charlemagne to concerns about coinage and justice, issues that did indeed greatly preoccupy him. What Vondel-Garius does is highlight that these are royal concerns, and in so doing, he reflects ideas that the court spent much time trying to propagate. The mere fact that in 793, a probable lay notary in probably Burgundy understood that coinage and justice were two of the major topics Charlemagne paid attention to is precious evidence that the concerns of the court, most clearly expressed in the capitularies, were made known in the regions of the still expanding empire. In some ways, this manuscript is only peripherally a capitulary manuscript. The one capitulary text it includes, the Decree of Childebert, is regularly transmitted with the Salic Law, and thus it is in this codex because of this link to the Salic Law and not because this volume particularly collects capitularies. Yet it is a capitulary manuscript in a looser, but perhaps a more powerful sense, in that it reflects how the ideas about rule articulated in Charlemagne's orbit filtered down into the localities of the empire. By referring in some way to Charlemagne in conjunction with all of the three main legal texts in the manuscript, and most notably by marking out passages linked to his concerns with clear symbols of Charlemagne's power, the manuscript absorbs the ethos of the capitularies. This is a manuscript not commissioned by or really connected to the court, as far as I can see, but it nonetheless demonstrates an understanding of some of the major ideas of Carolingian governance, ideas that Charlemagne's court had only recently begun to focus on after the first half of the reign spent largely on campaign. The way that Montgolfierius indicated royal interest by drawing symbols of royal power is quite unusual. The most 9th century manuscripts are not illustrated. The approach is particular to this scribe and this manuscript. Yet the manuscript allows us to glimpse a larger process in action, whereby royal ideas were taken up locally and interpreted in ways particular to those making use of those ideas. This is at the heart of why capitulary manuscripts are so essential to understanding the use of law in the Frankish world. Precisely because the manuscripts are local, they allow us to see different people and communities reacting to royal ideas and turning these to their own purposes. St. Gall 731, because of its named scribe, precise date, and unusual illustrations, is a particularly clear example of how capitularies, as they were received and interpreted locally, shaped ideas about law and rulership. As I noted earlier, the Carolingian court did not dictate clear rules or regulations about transmitting and distributing capitularies. The existence of manuscripts like this one suggests that leaving it up to particular people and institutions to react to capitularies worked, at least some of the time. Capitularies were flexible legal instruments, but they were in fact taken up locally in ways that reflect, but were not dictated by, the court. Scholars have often noted the many Latin mistakes in this manuscript, some of them so grievous as to distort the sense. Yet, despite the infelicities, the nexus the manuscript creates between law, Charlemagne, and concern for justice and coinage is a powerful and coherent reflection of royal concerns. This royal vision, translated here into a local and particular idiom, allows us to see in action the early stages of the process by which Charlemagne reshaped legal culture. Like any normative source, capitularies tell us what those who produced them wanted to happen, not anything about what actually did happen. The capitularies include some particularly ambitious passages, ranging from the difficult, like attempting to open numerous schools to teach proper Latin, to the utterly impossible, such as trying to ensure everyone in the empire, with the possible exception of the Jews, were truly Christian. They are, in a sense, a blueprint for the Frankish Kingdoms, an incomplete, sometimes contradictory, often redundant, ambitious plan for what the Frankish kingdoms should look like. Because they were so often copied locally, however, they can reveal for us not just royal aspirations, but local implementation. Copying a manuscript was both hard and expensive. The people and communities who chose to write down capitularies did so usually for their own benefit, not, or not only, because a king told them to. This feature of the manuscript corpus allows us to use these sources to study not only royal vision, but how that vision was taken up, modified, ignored, embraced, or reworked throughout the Frankish world. The capitularies themselves are, in a sense, a legal dead end. They would not contribute all that much to the future development of European law. But what they did do was offer a variety of resources, political, legal, religious, cultural, that people and institutions regularly put to work to try to save souls, or to define Frankish identity, or to insist on the necessity of just judgment. As such, the capitularies, and the hundreds of codices that contain them, were one of the major tools with which early medieval people shaped a world after Rome. Thank you.
thank you very much for this very rich and interesting presentation. I shall not try to summarize what you said, but started very generally and focused on a special study referring to one particular manuscript which offers us some glimpse into a local perception of what had been emanating from the center. So our speaker is willing to, we have some time, I think some 15 minutes for discussion, something like that, and our speaker is willing to answer more general questions, but also more specific ones. So it's up to you.
Fascinating. I used to study Merovingian and Carolingian texts 50 years ago. So I mean, this is. But what I wonder, could you say how the royal intention was spread to these remote areas that were then taken up by these scribes? How were they taken as documents that were systematically sent out, or how, and did they copy things that they were just interested in and not that the whole text, that they made a selection in their interest? Yep. Thank you.
Sure. So these are really important questions. So first of all, in terms of how ideas get circulated, the first thing I would say is that there's not one way of doing this. So, and that becomes part of the trick with the capitularies, is that the capitularies themselves say things like, the Missi need to check that everything that's been commanded in the capitularies has been done or enforced. So they refer to themselves in a way, and they expect that they have been transmitted. The evidence that we have in most cases does not support the idea of distribution from the court of set texts. There are exceptions, so the Admonitio Generalis, the big Reformed Capitulary of 789, the new edition for that has, I think, made quite clear that that is how it worked. Most of the time, it didn't work that way, so there is not centralized distribution. So what we need to do then is sort of work back from the manuscripts to try to figure out how are people getting these things. So when they copy them, people very much make their own selections in that they choose what they want to copy. That's not to say that there aren't relationships between manuscripts or there aren't texts that go together. So there are certain capitularies that tend to be transmitted together. So if you have one, you almost always have the other, which does suggest that they're even if it's not a copy from the court, they were written together and that's what's going around. Some manuscripts do edit in that they only keep some chapters. And one of the problems with the edition is that sometimes the edition has sort of created a capitulary falsely by taking passages from here and there and mushing it together and saying, oh, look, it's a new capitulary. And no. However, a lot of the time, what is actually interesting to me is that for many of the texts that are edited as separate texts in our best edition, which is the 19th century edition, until Stefan and others fixed that, the texts do have a coherence as text, so that if someone skips a chapter or two, they keep the rest in the right order. So that clearly there are copies that circulate. It's just not from direct. It's not everyone has to come to the court and make a copy most of the time. There is an attempt in the reign of Charlemagne's son, Louis the Pious, to try to do that, and it doesn't work, basically. So there is some reaction to text coming from court, but there's a lot of local flexibility. The other part of that answer is that there are a lot of other ways that the ideas get articulated. So assemblies, I think, are a major thing that people hear this. The idea being that important people come to court and they start hearing this stuff, but then that there should be local assemblies where they repeat it. And we know these kinds of meetings happen, and a lot of it probably is being done orally. So in the case of something like this, I don't know that we would need to imagine somebody like Vondel-Garius has actually sat there and read a bunch of capitularies, but that he's had enough context that he's getting the point that these are things that are important to the powers that be. Does that help? It's a complicated question, but.
questions. Yes.
We know from other sources that Charlemagne successfully aspired to the unification of some texts, for example, the Bible,
Yes.
sacramentary, other texts as well.
Yes.
Now, I wonder why he didn't manage to unify the capitularies.
The first thing I would say is that I think Charlemagne's a lot less worried about unity than people often assume. I mean, to be honest, he had a lot of problems. I mean, this may sound ridiculous. He conquered, most of Europe. Life is pretty good. On the other hand, he conquered half of Europe, not all of whom actually want to be ruled by him. So, this is a court that often is hanging on by a thread. Okay, so my interpretation of Charlemagne's reign has been very much that he insists when it matters, and he lets a lot of other things go. So you need to be Christian, you need to be loyal. Most other things he can work with you on. So I would say. So one, just as a general principle, I'm not so unity. In terms of standardization of particular texts, he does do that on occasion. So he does sponsor might be too strong. He does encourage a revision of a biblical text, and I think the difference there is that this is sacred. This is God's word. You need to get it right. His legislation doesn't have the same quite resonance. You need in terms of his legislation, you have to get the point. And there are a lot of different ways to do that. I'm not sure he would have been totally opposed to the idea of standardizing his capitularies, but I don't think he ever tried. So I don't think it's solely an accident that we don't have this. I think there's not any concerted effort to do so.
From your lecture,
Yes.
I might deduce that it was first not only intended that they were uniform, but it was taken for granted that they were not uniform.
Yes, yes.
Local use,
Yes.
something.
Absolutely. I think that, yes, I think that there's a lot of room for local use.
Thank you so much. It was wonderful. I got particularly fascinated by the moment when you said Salic Law. I was like, oh, that's interesting. I know something about Salic Law. So I was just very curious about how does a law like the Salic Law, which, from what I remember, later on in history, caused a lot of problems, and maybe at some point, maybe they wished they hadn't had this law. How does it fit with this other kind of law? Was it also a law propagated through this kind of copying, or was it more important, or did it have a different status?
Salic Law versus the other kinds of
Yeah.
national laws?
Yeah, and then a little sort of aside is, I'm wondering if this form of, publishing or, publishing these laws, if it gives them a kind of authority or weight that makes them more difficult to change or amend, or does that matter at all? Thank you.
So some of the later historical references to Salic Law, particularly as it feeds into the French succession, is basically a late medieval, early modern invention that has nothing to do with Salic Law, actually. So as it becomes known, it's not the actual Salic Law. The Salic Law itself, is it more important? No, it's just that in a sense the Franks win. So of the people in the post-Roman world, they're the success story, which is in some ways surprising. If you had sort of sat there around in 500 and were looking at who's going to win, probably wouldn't have been your first choice, but they do. And I think that's one of the major reasons. So, for example, the survival of the Salic Law is much bigger than any of the other so-called national laws. There's, I think, 90? Is it 90? I think it's 90 Salic Law manuscripts. The next most is the Alemannian Law, which I believe is 55. Stefan knows more about national laws than me, which is why I'm checking everything that I say. Alemannian Law is somewhere in the 50s. The Bavarians, 30-some manuscript copies. Lombard, 11. So, Salic Law at 90, so the Lex Romana Visigothorum, which is, again, it's not just Visigothic, it's also a Roman, is more, but Salic Law, there's just more of it, and that I think it's because the Franks win. So that I wouldn't say it has a greater intrinsic importance. In terms of changing them, yeah, they get changed all the time, which is part of the problem, which is part of, when I was introducing these laws, I was saying constantly, it is generally argued that there are two versions, but, because the reality is for the vast majority of the national laws, figuring out the differences and the relationship between the different copies is really hard. These are texts that, and to some extent then, I think that becomes part of the argument why we have to see them as not purely ideological, because people constantly rewrite them and change things. And if you were just keeping something because you wanted to make the statement of law, why do you bother to change it? Now, the ways in which those changes happen are complicated, and dating them is even worse. But I think there are certainly laws that people tweak. There are also a class of capitularies that add to the national laws, sometimes more closely than others, where they consciously set out to revise them. And then we have some narrative evidence, for example, of commissions of laws where they're supposed to go through them. So the national laws tend to have things like about crime, about inheritance, about social status, freedom, manumission, those kinds of things. And yes, they're constantly subject to change.
Yeah.
Thanks. I have a very specific question about that manuscript, if you'll indulge me.
Yes.
Because I assume that those two clauses aren't the only one on justice and coinage.
Yeah.
So do you think there's anything particular about those that they specifically would be marked as royal?
Yeah.
Or is it just like a general theme that's marked here?
Yeah, I think all I can say is I think he's marking a general theme, and obviously he's not going through and looking for every single reference to coinage or justice. So you're quite right. As I said, going through it, I can't find that there's anything in these particular chapters that are precise. You could get closer in certain places, but again, I think that what's going on here is much more, it seems to me, given the ways in the corpus overall of ways that Charlemagne is evoked, that it's much more general sense. But no, he certainly doesn't do it consistently. Those that I showed you are the only two Charlemagne symbols in the illustrations.
Thank you for that wonderful presentation. I learned a lot about it, and especially about this, about these symbols that you showed us, because we've been talking about them just 2 weeks ago, actually, in our seminar,
okay.
And we were wondering what they might mean in this context. But I was particularly puzzled about the dating clause that you showed us on the 26th regnal year of Charlemagne, which was, I think it was underneath the Salic Law.
Yeah.
And actually, you mentioned that this version of the Salic Law was, or is actually dated to his father,
Yeah.
Pippin. So,
Yeah.
and Karl Ubel argues, as you know, that this version was useless, basically, because there were so many mistakes in it, and it was a completely senseless, not completely, but it was a text that was not useful in any meaningful sense, but it was more of a, well, how to say, symbolic usage only. And now you showed us how people could still use it 20 years later or 30 years later, as well as a means to transport the royal ideology of laws and so on. And picking up on Eve Overgaard's question on unity, I mean, you need to tell people that, or we need to know that of this seemingly useless versions, there are only 2 copies. And the ones that Charlemagne's commissioned later on, there were about 40 or so. So the K version, or even more than 40 versions. So the unity is actually deceivable, you know, it's actually there. Somehow there are these older ones that get copied all the way through, but there are only a few copies and not that many. So that was not really a question, but more of a remark. I'm sorry.
Yeah. No, I mean.
Anyway, very interesting.
You're absolutely right, and the D version that we have here is only in 3 manuscripts. So the idea being that the Salic Law had become in many ways outdated and in need of attention. Pippin sort of makes a like first effort. Charlemagne makes a first effort, not very good. And then it's only the sort of Charlemagne's second try that actually sticks with the Carolina. And then, of course, that becomes the dominant. The Carolina is, I think it's actually like 20 of the 90. I mean, 70 of the 90. It's huge. It's the one that goes. But it takes a while to get that. That's including all the manuscripts, which continue far beyond, the actual reign of Charlemagne. So in that case, the Carolina is so much obviously better that yes, you eventually get that unity. So that's definitely a fair point. I'm not sure you get it already under Charlemagne. And then again, I think your point raises the question of what exactly overall this manuscript was meant for. The argument that I was trying to make is that it's reflection of this capitulary culture that's just sort of getting off the ground here. And that you have this scribe who is sort of, if nothing else, gotten the point that like justice, coinage, king, these things go together. But I do think that you have a major problem here, and it's not one that I offered an argument about, partly because I can't decide what I think about, which is the actual purpose of this particular manuscript. You have one school of thought that argues, McKitterick in particular, that it's a book for account, that someone's actually going to judge from this. I gotta say, I find that hard to imagine. Yeah, not even that. It's a mess. I mean, it's not just it's a bad version, but like some of the. I mean, the Latin just is incomprehensible. Detlev Liebs argued, because he edited the transcription of the version of the Lex Romana Visigothorum, which is particular to this manuscript, just nowhere else. And he argues that it was copied from dictation rather than copying, so maybe they just misheard it. But did anyone read? I mean, nobody corrected it. I mean, there's some things where it's just, if you know anything about law, it's egregiously wrong in a couple places. So I gotta say, I'm not really convinced that Rosamond in that particular case is right that this is used. On the other hand, the kind of short argument that this is sort of like this statement about the coming of empire, I don't find that convincing either. I mean, one, I don't really see the empire part here, or a very strongly Christian framework to this manuscript. I mean, there is a genealogy of Jesus, but this is a very Christian society, so that alone to me doesn't make this like a Christian statement. So I am willing to believe that it is some kind of more school text or ideological text, though what that purpose is, I don't know. I certainly don't think it's sort of any kind of, again, statement of empire kind of thing. So that leaves then unresolved the problem of what exactly is going on with it. It's interesting to me for, again, I think what the way that recognition of this is what Charlemagne's worried about, which is, again, a very diffuse sense of legal law. But I don't know that I have a great answer for overall why he made this book. If you have a better one, I'm happy to hear it. But or Stefan.
I think as a whole one can distinguish when legal manuscripts are concerned of any period, any given period. Mm-hmm. Some manuscripts are made for legal practice at courts of justice, for practitioners of law, and others were made for studying copies, for studying purposes, in sort of schools in any forms. Right. And these can be distinguished, I think. Yeah.
Yeah, absolutely. And, there are copies that I think very much are used to judge from. I mean, there are manuscripts that are quite specific and for particular themes and short and small and, you could stick them in a saddlebag and great. And then there are things that quite clearly I think are school texts that also have texts sort of about the nature of law next to a range of different texts. So I think they exist. This one to me doesn't totally fit into either of those categories easily, which is, I think, part of the challenge. Do you have an opinion? No. I'm worried about Rosamond's idea of the count.
No, but it could be interesting to know more about the development of the monogram actually in charters at this time, at what stage this is inserted and whether these years 793 or 4
it's not new.
In any way relevant.
It's not new for the monogram though.
Yeah.
The coin's new, but the monogram no. Because, I could go back to it, but I don't think so.
There's some endeavor for authentication, obviously.
Yeah, absolutely.
And this seems important.
Yeah, the one thing I will say is the monogram alone does suggest he's seen a royal charter, which for a notary is not crazy, but not everyone's seen a royal charter.
Okay.
Just on that one, would he have to be authorized to use the royal monogram, or could it be usurpation of this to use the authority of the king for his local authority?
I don't think in this. I mean, this is so obviously, you know, a royal charter. Looks like this. So I don't think you're going to mistake the manuscript for this. So, I mean, if you were trying to forge a charter, yes, we have a problem. But that he, you know, so that the use is illicit, I don't think so. No, that he's trying to get some kind of local authority by using it, entirely possible. Absolutely. I don't think, you know, in a sense of trying to fake royal authority, but that he, yeah, that it makes, yeah, sure. Entirely possible.
Okay, one last question.
It's brief and it's for you, actually. I'm just kind of curious what a new edition of a lot of these laws will allow. Presumably, one of the things that will allow is some sort of a concordance, some sort of a you know, searching for common denominators between all these different 250 and 300 laws. So, since you are really the expert here, maybe you can give us a preview, given that we've already gotten one approach of what are some other possibilities that new edition will allow.
Actually, when it is finished, I will have retired probably. So no, it's basically it's a project which is based on two different strands of research. The one is actually what Jennifer is doing is looking how these texts were copied into manuscripts, how they were collected, assembled within collections, and which is very important as you have a unique insight into the reception and the perception of this legislation, also in the use of these texts. So it is important, and this is an online edition of individual collections which you can search then, and you can see how the reception of these texts was and to what extent they differ. And the other thing is a traditional edition that we try taking all these extant copies we have and finding out how an original capitulary may have looked like. So it's a twofold objective actually within this project, and it's, well, I'm only part of a team doing that. So, but what Jennifer said is actually it's one side of the coin also of our project, and so it fits very nicely to what we are doing. So. Great. Thank you all for, well, of course, for coming, but also for participating in the discussion. And in particular, thanks very much again to our speakers.